Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Only 2 cases this week, thank the gods. So I'm going to give them both the depth of attention that they deserve. But not before singing to you all. Thank you, podcast Patreons, for being so good to me. For supporting this nerdy podcast and helping the MBRC. Listen about case law. Alright, I lost the thread. I really appreciate all the patrons who support the show for no other reason than because they appreciate this podcast. As always, and as you all already know, let me know if you ever need anything. Before getting to those 2 aforementioned cases, I'd be remiss if I didn't mention that also this week, the Second Circuit amended its episode 219 Garcia v. Garland decision, quote, to clarify this circuit's interpretation of the Supreme Court's opinion in Wilkinson v. Garland, end quote. A quite brief clarification at that. And then also the Ninth Circuit took out one sentence of its Bent bomber from a few weeks ago, at the petitioner's request. Go listen to Bent again just for the fun of it. With the Ninth Circuit decision that I'm about to do in this episode, crimmigration is getting very interesting in the Ninth. Was it ever not? Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. With an entire team of professionals, including psychologists and mindset, task, and performance coaches, Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. Or, of course, click on the link in the show notes. Welcome to week 228. As appropriate a time as ever to start off with matter of RTP, published by the BIA. The saga of deficient notices to appear returns to the podcast with a vengeance. Mr. RTP is from Cuba and was placed in removal proceedings by being personally served with an NTA that lacked the date and time of his first hearing. It had the court, though, San Antonio. The date and time was eventually provided to him in a follow-up notice of hearing. That makes it a deficient NTA. What to do about it? 14 pages single-spaced and lots of case law to get through. The immigration judge properly recognized that this meant that DHS had violated a mandatory claims processing rule. Then, relying on matter of Fernandez, the IJ terminated removal proceedings for this violation. This, despite DHS trying to remedy the non-compliant NTA in court by doing three things. 1. Filing a Form I-261 amendment to the NTA. 2. Filing a copy of the first page of the non-compliant NTA as an exhibit with a written amendment reflecting the date and time of the respondent's initial hearing as presented on the first notice of hearing. And 3. Requesting that the immigration judge, him or herself, make the necessary written amendment to the date and time contained on the non-compliant NTA. The IJ didn't believe that any of that was proper and, as I mentioned, terminated proceedings, as matter of Fernandez allows. DHS appealed. The BIA remanded. Again, no question that this NTA is deficient, as it does not comply with INA Section 239A1, making it a violation of a mandatory claims processing rule, as we all now know. The history of all this is well worn on the pod, and I shan't repeat much of it. Importantly here in matter of Fernandez, quote, although we rejected the argument that the only appropriate remedy for a violation of this claims processing rule is the termination of proceedings, we left open the question of the precise contours of permissible remedies, noting that the nature of the violation should inform the nature of the remedy, end quote. No one knew what that meant, at least no one that I know, and I know everyone. But the BIA did later hold that DHS can't remedy a deficient NTA through the filing of a Form I-261, which made perfect sense to me. That's matter of Aguilar-Hernandez. And to me, at least, it truly seemed that we were on a path whereby the BIA was going to hold that the only proper remedy for a deficient NTA was termination of removal proceedings, whereby DHS could then decide or not decide to re-NTA a non-citizen. But then Justice Alito issued his decision in Campos-Chavez v. Garland, the rationale of which people smarter than me probably understand better than me. There, the Supreme Court majority held that in the in absentia reopening context, a follow-up notice of hearing can essentially fix a deficient NTA, at least such that reopening isn't required in the case where the non-citizen is ordered removed for not showing up to their hearing. And here we are. Not, of course, in the in absentia reopening context, just in the regular deficient NTA initiating removal proceedings context. The BIA first explained that Ms. Chavez out of the Supreme Court teaches us that to be a proper NTA, all the required information, including the date and time and location of the first hearing, must be in a single document. Quote, the single document requirement, however, does not mean that a document once submitted and filed can never be amended, end quote. Explained the BIA without citation. But, quote, general principles and jurisprudence regarding litigation and amending of documents, especially case-initiating documents, provide helpful guidance in this regard, end quote. After all, defective criminal indictments and civil complaints can be amended in criminal and civil court, explained the BIA, which of course is very true. So why not immigration court proceedings as well? Essentially queried the BIA as the underlying logic of this entire decision. Right out the gate, though, the difference to me, and this is just me, is that amendments to criminal and civil indictments and complaints respectively include new information that is to be adjudicated prospectively. New indictments and new civil complaints essentially restart those proceedings. Not so with what DHS is trying to amend here. They're trying to amend a case-initiating document to include information that was lacking and for something that has already happened in the past to comply with what is essentially a procedural rule. That seems a bit different to me. Taking this civil complaints analogy further, if, for example, I filed a naturalization petition in federal court and failed to comply with the federal court's filing fee requirement or didn't include the mandatory cover page, I wouldn't have an opportunity to amend my petition. My petition would simply be rejected by the federal court, and I'd have to start it all over again. Isn't that more analogous? So isn't the answer here really that the immigration courts should be rejecting DHS's NTAs where those NTAs don't comply with INA Section 239A? Might that be the more direct and reasonable answer to all of this? But I digress, of course. The BIA, of course, did not choose that path and went through the proposed remedies that DHS was asserting here, and decided that whatever it chooses, the choice must result in a single case initiating document that is consistent with the rules and procedures governing immigration court, that help promote the underlying purpose of this claims processing rule, and that do not prejudice the respondent. What is the remedy then? Drumroll, please. Well, it can't be DHS's first proposed remedy, the Form I-261. BIA precedent already precludes that. Nor can it be DHS's submission of the first page of an already filed NTA with the previous stuff crossed out and the true eventual date and time handwritten in where it didn't exist before. That wouldn't be containing everything in a single document as Ms. Chavez requires, explains the BIA. Also, ICE trial attorneys aren't one of the 45 different DHS officers who can issue NTAs per the regulations, so such a proposal would violate the regulations too, explained the BIA. Also, that's ridiculous, says me, and clearly shows that DHS thinks that all this claims processing rule compliance stuff is ridiculous too. Quote, while we recognize DHS's argument regarding the time and labor involved in returning a case to an official authorized to issue a notice to appear under 8 CFR section 239.1a, the Supreme Court has long made clear that practical considerations and pleas of administrative convenience do not justify noncompliance with procedural obligations. End quote. Also, this is all improper because INA Section 239A1, quote, clearly requires that a notice to appear contain a future date, not a date already passed or the date of a past hearing, to enable the respondent to attend the future hearing with counsel if desired, end quote. Interesting. Kind of what I said above before. So how are we going to square that, BIA, that is, requiring a future date in this NTA when, of course, by definition, we're already at a hearing? And so it can't be the first hearing. Well, first off, in a footnote, the BIA says that DHS can obtain a properly signed and authorized superseding NTA and file it, presumably with a future date for the hearing, in the same proceedings where the deficient NTA exists. The dissent in Fernandez explained why this wouldn't work under the regulations, but the panel here has blessed it. Additionally, explained the BIA, for purposes of this case, DHS may move the IJ to, quote, make written amendments to the notice to appear by adding the date and time of a future hearing, end quote. To comply with the statute, the amended future hearing must be, quote, no fewer than 10 days, end quote, after the date of the amendment. To the BIA, this would satisfy Ms. Chavez's technical holding that all required information be in one single document. It's also consistent with the IJ's, quote, broad authority to grant motions to amend documents in removal proceedings, end quote. So I guess remember that power. After all, IJs do routinely amend NTAs for other reasons on DHS's motions, and amend relief applications for typographical errors. And it's only the immigration court that controls the dates and times of future hearings anyway, explained the BIA. This remedy also promotes the purpose of this mandatory claims processing rule to the BIA, which is to, quote, promote the orderly progress of litigation, end quote. And even achieving this remedy depends on timely objection to the NTA, by the way, everybody. Rejecting the respondents' and amici arguments to the contrary, the BIA explains that, quote, while the requirement that a notice to appear include the time and place of the hearing serves an important goal, the burden on respondents, whose removal proceedings are initiated by a non-compliant NTA, is similar to the burden placed on those in proceedings that are initiated by a compliant NTA, end quote. Now, it seems like the BIA is sanctioning termination in some cases. Quote, whether the remedy satisfies the fourth requirement, that it not prejudice the respondent, requires a case-by-case determination, end quote. But to get termination, then, it does seem like a prejudice showing will be required. A bit unclear. But if that's the case, it seems like we're right back to where we were a few years ago with all of this, after some wild swings at the circuit and the BIA. We are kind of going in circles here because the BIA really, really, really does not want to simply sanction termination of removal proceedings and require DHS to comply with this mandatory claims processing rule. So, the BIA has issued its non-compliant NTA guidance based on what it thinks proper and what it believes most consistent with Congress's desires. Presumably Merrick Garland's as well? We shall see if the circuits and maybe even the Supreme Court agree. And that is a matter of RTP. Attention lawyers looking to dive into immigration law. Are you ready to master the art of marriage-based immigration? Introducing the Ultimate Marriage Green Card Course, a comprehensive resource by John Khosravi, founder of the Immigration Lawyer's Toolbox, to kickstart your journey in family-based immigration. His course offers 18 hours of engaging video content and includes monthly office hours for your questions. You'll analyze and learn, through the statutes, regulations, case law, and real-life practice, essential topics like 212 inadmissibility, 245 adjustment, consular processing, and the affidavit of support requirements. The course will also cover practical office procedures, consultations, and sales techniques. Plus, you'll receive helpful samples and templates to streamline your practice. As a limited-time special bonus, the Immigration Lawyer's Toolbox is adding the recordings of an all-day O1 seminar with the best O1 lawyers in Los Angeles. Go to immigrationlawyerstoolbox.com and click on the course link, or email John at info@immigrationlawyerstoolbox.com to sign up. Reference me, Kevin, or the Immigration Review Podcast and get an additional 10% off. Or of course, click on the link in the show notes. We conclude then with United States v. Perez Garcia, published by the Ninth Circuit on September 4th, 2024. If that last BIA decision depressed you a little bit as non-citizens counsel, well, here's this. This case is about crimes of violence in the sentence enhancement context. But it's the same immigration definition at issue, and it's an important and often charged statute. Cal Penal Code Section 245A1, assault with a deadly weapon other than a firearm. A district court held that the conviction matched the definition of the sentence enhancement crime of violence, meaning that Mr. Gomez, who got that conviction in California previously, got even more time for his federal conviction of distribution of methamphetamine. But the Ninth Circuit disagreed. Don't get me wrong, Mr. Gomez is serving prison time for the meth, but not additional time because of the prior conviction. And the reason is because of the Supreme Court's decision in Borden, Episode 59. It's all about mens rea, the least culpable mental state required to convict in California. The Supreme Court in Borden taught us that the sentencing guideline crime of violence definition only includes state criminal statutes that, quote, require mens rea more culpable than recklessness, end quote. And of course, the Supreme Court in Borden noted that this is a materially identical definition to the one at 18 U.S.C. Section 16A, and therefore the immigration crime of violence aggravated felony. The Ninth Circuit also says as much here in footnote 1 as well. Go back to Borden and read all the reasons why. It's interesting, and the Ninth Circuit goes through it all, but ultimately, the Supreme Court has spoken. Quote, a person acts recklessly when he consciously disregards a substantial and unjustifiable risk, end quote. This as opposed to, say, intent, which occurs, quote, when a person consciously desires a particular result, end quote. And if you're curious like me, because I'm always wondering what a knowing mens rea is as opposed to intent. I'm sure I learned it in law school, but I forgot. Well, here you have it. Knowing is higher than recklessness, and so would make a crime of violence if that is the least culpable mens rea required of the statute. But specifically, quote, knowledge is defined as awareness that a result is practically certain to follow from a person's conduct, end quote. The more you know. See what I did there? Anyway, there you go. The mens rea scale. Intent, knowing, and recklessness. Negligence is even less than recklessness, by the way, so it's not even considered, because even recklessness is now too low to make something a crime of violence. And wouldn't you know it, assault in violation of Cal Penal Code Section 245A1, assault with a deadly weapon, that is not a firearm, permits conviction where a person acts recklessly. Even though the statute requires use of a deadly weapon, and even though the statute doesn't list a mens rea requirement at all, California courts have incorporated the simple assault definition used in California at Section 245A1, and have so permitted conviction through mere reckless conduct, explains the Ninth Circuit. It's actually exceptionally complicated and has been continuously analyzed for like 150 years, explains the court. But, quote, the prevailing definition of the assault mens rea, according to the California Supreme Court, is an intentional act, an actual knowledge of those facts sufficient to establish that the act, by its nature, will probably, and directly, result in the application of physical force against another, end quote. The Ninth Circuit explains that actually that's even less than recklessness. Simply put, assault in California, even with a deadly weapon, does not require, quote, a subjective awareness of the risk that an injury might occur, end quote. California case law supports all of this. You see how powerful this is? Even though the statute literally requires use of a deadly weapon, and even though the Ninth Circuit has a plethora of prior precedent, holding that this very statute is a crime of violence, Borden has wrecked it all. Section 245A convictions, seemingly all of them, are no longer crimes of violence because they incorporate simple assault, which in turn in California requires the mens rea of recklessness, and Borden teaches us that mens rea is determinative. That is a big deal. That vacated precedent, it would seem, includes United States v. Grajeda, by the way, which ICE relies on all the time in California immigration courts. No longer good law, said the Ninth Circuit. Many more cases listed, too, as no longer good law. Quote, in sum, Borden establishes a bright-line rule. If a statute criminalizes use of force committed only when a conscious disregard of a substantial risk to another person, it is not a crime of violence. Our prior cases do not apply that test, and thus improperly categorize Section 245A1 as a crime of violence in violation of Borden. They are not merely in tension with Borden. They are irreconcilable, end quote. Big deal. Judge Soto in concurrence would go even further and hold that the Ninth Circuit's Episode 106 en banc United States v. Big Guy decision concerning the mens rea of extreme recklessness and second-degree murder also might be bad law under Borden. But if I'm being honest, that's a pretty hard sell for a variety of reasons. All of it means, though, of course, congratulations to Todd W. Burns of none other than San Diego, California, for Mr. Garcia. I'm sure you don't know how important this is for immigration people, but thank you nonetheless. Anyway, huge decision. And what about this? Based on my records, I discussed Cal Penal Code Section 245A4, assault on Episode 46, matter of Aguilar-Mendez, in the CIMT context, and Cal Penal Code Section 245A1 itself on Episode 21 in Safarian v. Barr, also in the CIMT context. Is that still good law? A CIMT, of course, isn't an aggravated felony crime of violence, and they have different definitions. And it's pretty black letter that under the right circumstances, a reckless mens rea can satisfy the crime involving moral turpitude definition. However, in Aguilar-Mendez, the BIA based its rationale in part on a belief that the California statute, that is 245A4, requires, quote, an intentional violent act, end quote. So too, Safarian was based in part on Chevron deference and a belief that Section 245A1 required a mens rea akin to criminal recklessness, above mere recklessness. Both of those rationales seem incorrect now, right? And both of those decisions predated Borden. If nothing else, they're on shaky ground, right? What do you think? Give it a brief. And that is United States v. Perez Garcia. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook @Immigration Review, or send us a tweet @ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.